Legitimate to bear in mind the preemptive significance of Part 4 in understanding the Constitution. 88 to 8921, 70 Supreme Court Reports, 973, Sups. C. R. Roydance of amending power. Despite the marginal note to Article 368, which indicates that Article 368 is prescribing the procedure for amendment, SEVC, all considerations clearly show that the amending power is located in Article 368. The power cannot reasonably be located in Entry 97 of List Y of Schedule. Vil read with Article 248 of the Constitution. Article 368 provides specifically for a procedure for amending the Constitution, and when the prescribed procedure is followed, 11 the Constitution shall stand amended in accordance with the terms of the bill. Who can bring about a certain result may truly be said to have the power to produce that result. Power to amend the Constitution is accordingly necessarily implied in Article 368. The procedure prescribed in Article 368 is the exclusive procedure for amendment of the Constitution. The word "only" in Article 368 rules out all other procedures for amendment P. 92 to 894. Nature of amending power. The amending power conferred by Article 368 is a constituent power and not a legislative power. The framers of the Constitution made a distinction between legislative power and constituent power. Broadly speaking, one constituent power determines the frame of primary organs of government and establishes authoritative standards for their behavior. In its ordinary sense, legislative power means power to make laws in accordance with those authoritative standards. Legislative power determines the form of secondary organs of government and CSTFL, establishes subordinate standards for social behavior. Subordinate standards are derived from the authoritative standards established by the constituent power. The distinction between constituent power and legislative power in a controlled constitution proceeds from the distinction between the law-making procedure and the Constitution amending procedure. Our Constitution is of a hybrid pattern. 'Tis partly controlled and partly uncontrolled. When any part of the Constitution is amended by following the legislative procedure, the amendment is the result of exercise of the legislative powers. When it is amended through the procedure prescribed by Article 368, the amendment is the result of the exercise of the constituent power, pp. 894 to 896 or, in re. the Judicial Laws Act, 1951 SCR 787, 8 and 12 referred to. Dominion of amending power. The phrase amendment of this Constitution is the nave center of Article 368. It is determinative of the dominion as well as the magnitude of the amending power. The words "this Constitution" embrace the entire Constitution. The preamble is part of the Constitution. Thus, the amending power can amend each and every provision of the Constitution, including the preamble in Part 3 pp. 897. Magnitude of the amending power. The framers of the Constitution enacted Article 368 for several raisons. First, the working of the Constitution may reveal errors and omissions which could not be foreseen by Clickm. Second, the court's construction of the Constitution may not correspond with the Constitution maker's intention, or may make the process of orderly government difficult. Third, the Constituent Assembler which framed the Constitution was not elite on adult franchise, and was in fact not fully representative of the people. The Constitution makers conferred wide amending power on Parliament because it was believed that Parliament elected on adult franchise would be fully representative of the entire Kesavananda Bharati, Dwivedi, J. 71. People, and that such a Parliament should receive a right to have a fresh look at the Constitution and to make such changes therein as the entire people whom it represents desire. Fourth, at the apex of all human rights is the right of self-preservation. Self-preservation implies mutation, that is, adaptation to changing environment. The nature, object, and history of the amending power and the context of Article 368 leave little room for doubt that the word jamkindamkanti includes the power of repealing or abrogating each and every provision of the Constitution. It may be that Parliament may not be able to annihilate the entire Constitution by one stroke of pen, but it can surely repeal or abrogate all provisions of Part 3, The amending power in Article 368 is unlimited and uncorefinct as the power of Constituent Assembly. Indeed, it may truly be aid that Parliament acts as a Constituent Assembly state of Madras there be. Champakam Dorai Ryan, 1951, SCR 525, and Kamarwar Singh v. State of Bihar, LR 1951, Patna N, referred to Pew. 897 to 903 meaning of law in Article 13.2. There is a distinction,